Welcome to the podcast Legal Pawns, spotlighting how the American justice system uses its citizens for a game of greed, political gain, and control. We are here to educate, empower, and facilitate change through truth and facts.
Hello, and thank you for joining me for another episode of Legal Pawns. I want to spend this episode talking about some facts and figures of the United States justice system. I think it's really important that we raise awareness of what is happening in our country and really dive into why it is happening. In a 2018 PAW research finding, those individuals charged with a federal crime, 90% plead guilty, 8% had their case dismissed, and 2% went to trial. Out of those who went to trial, 83% had a conviction rate. 17% received an acquittal. Let's put this in perspective. I'm going to give you a choice. I'm going to either give you the choice of getting on a 100-foot ladder, putting on a bungee cord, and I tell you that if you jump, you have a 90% chance of making it. Your other choice is I can take you to the Golden Gate Bridge, again, secure a bungee cord to you, and when you jump, you have a 17% chance of making it. Which one will you choose? This is what it is like for the individual in this predicament. If they take the deal, the time is shorter. If they don't take a deal, they go to trial, which means that they have an 83% chance of being found guilty and spending more time in prison. Your thoughts may be the investigators, prosecutors must have a strong case in order to get this type of conviction rate for 90% of the population to plead guilty. Or a group of my peers surely will hear the facts and find me innocent. Or I'm innocent and the jury will see this. Once you are formally charged with a crime, you only have approximately 26% chance of being found innocent. Let's look at some of the contributing factors to this phenomenon. In an article published in 2001 titled The Prosecutor's Duty to Truth by Bennett L. Gresham, I quote, "Curiously, despite extensive documentation of erroneous convictions, widespread prosecutorial abuses that contribute to wrongful convictions, and a plethora of academic literature on the ethic responsibility of prosecutors, there has been little discussion of the prosecutor's legal and ethical duty to truth." Unquote. What does this mean? In my interpretation of this, I believe we see this many times. The prosecutors hide evidence that could help the defendant, or they may stretch the truth on something. I'll give you an example of this. A man was on trial for faking an injury and claiming for benefits. The prosecution kept referring to the man as being employed and in charge of an aquarium. So let me ask you, when I say aquarium, what do you think of? Just curious. Most people would say a large building housing large exhibits. In fact, the man was a backup to the person who was actually in charge, and the aquarium was only 400-gallon saltwater tank. Newly elected Los Angeles District Attorney George Gascon leads one of the largest DA's offices in the United States. Gascon just resigned from the California District Attorneys Association. Let me repeat that one more time. Gascon has resigned from the California District Attorneys Association. Wrap your head around that one. Why he resigned? He noted that the organization has lost touch with the public. Its members are elected to represent and serve. Let me quote from the California District Attorneys Association's website. I quote, "The mission of the California District Attorneys Association, CDAA, is to promote justice by enhancing prosecutorial excellence." Unquote. The district attorney of one of the largest offices in the United States does not feel that an organization that is for prosecutors is upholding their mission. Now let's take a look at another factor in the system of conviction. I am quoting from a January 1985 interview in New York Daily News. I quote, "Sol Watchler, former chief judge of New York, proposed that the state scrap the grand jury system of bringing criminal indictments citing that the district attorneys now have so much influence on grand juries, by and large, they could get them to indict a ham sandwich. Watchler stated in another interview, I quote, "Grand jurors operate more often as a prosecutor's pawn than the citizen's shield," end of quote. Do you know that the grand jury is actually secretive? Quoting from Wikipedia, I quote, "No judge is present. The proceedings are led by a prosecutor, and the defendant has no right in his case, or in many instances, to be informed of the proceedings at all. While court reporters usually transcribe the proceedings, the records are sealed," unquote. A lot of people's thought processes go something like this. An investigator shows up. They act like they're your friend. They just have a few questions. They're trying to clear up something. It's just a misunderstanding. You think, hey, I'm innocent. I want this clear too. If I answer these questions, it'll go away. And so you start answering away. They go away. You hear nothing. You think, okay, we resolved that issue. I haven't heard anything. In the background, what you do not know is your case has gone before a grand jury and they have decided to indict you. You have no right to be informed that it went before the grand jury. You have no right to appear before the grand jury and tell your side of the story. You have no right to hire an attorney to present your case to the grand jury before the indictment is given. Doesn't seem fair, does it? Once you get into the snares and that indictment has been handed down, again, you only have about a 27% chance of ever finding your freedom again. Life as you know it is pretty much going to change. Many people take a deal because of the mandatory minimum sentencing laws that we have here. I quote from the Criminal Justice Policy Foundation, quote, "Mandatory minimum sentencing laws force a judge to hand down a minimum prison sentence based on the charges a prosecutor brings against the defendant, which result in a conviction, usually a guilty plea. Many states have such laws. These laws take away from a judge the traditional and proper authority to account for the actual circumstances of the crime and the characteristics of the individual defendant when imposing a sentence," unquote. Quoting from the Indisputably website, an article by Jen Reynolds quotes an article in Opt-in and New York Times from Scott Hetchinger, attorney and policy director for the Brooklyn Defender Services. I quote, "From the perspective of negotiation, mandatory minimums represent a credible threat that prosecutors can use to convince a defendant to take a deal. One possible upside of mandatory minimums is that they remove some discretion from prosecutors and judges and create more knowns in a process that is largely opaque. But this loss of discretion arguably makes bargaining power even more disparate in favor of the prosecution, which can use the minimums as strong negative leverage in the negotiation. This leverage, in addition to the prosecutor's already large number of persuasive tools, e.g., exploding offers, adding enhancements and charges, etc., helps explain why even innocent people might choose to take a plea," unquote. Let's take a little bit of a closer look at this. If you don't take a deal, they can start stacking charges against you. What is charge stacking? Quoting from the Courtroom Workgroup Wikipedia, quote, "Charge stacking is a process by which police and prosecutors create a case with numerous charges or numerous instances of the same charge to convince the defendant that the risk of not pleading guilty is intolerable," unquote. So what this could look like is that you're charged with a crime. They come to you and they say, we're going to make a deal with you. If you take this deal, you plead guilty and we'll give you a year of house arrest. And you say, absolutely not. I'm innocent. They go away. They add more charges. They come back. Okay, you refused our first offer. Here's a second offer. You take a plea deal. It'll be a year of house arrest again. in addition to 3 years of probation. You again turn them down. Nope, I'm innocent. I am not taking that deal. They add more charges, which means, by the way, as they're adding these charges, your time, if you are convicted with a jury, goes up. So you originally were looking at 2 years in jail if found guilty. Now you're suddenly looking at 10 years if you don't take this deal. Their deal comes down. Okay, this time around, we are offering you 3 months of prison time and 3 years of probation. Can you imagine the pressure that these people are feeling? Their lives are under a microscope. They're losing family, they're losing friends, they're losing time at work, or they're losing work at all. They may have been fired by now. They may be going through their savings and selling everything that they know to try to defend themselves. They're scared. They don't know what is happening to their lives. Do they take this deal? Do they worry about the jury? What are they going to do? Let's talk about the right of a speedy trial. We've all heard this in the courtroom dramas. You have a right to a speedy trial. In a publication titled Constitutional Limitations on the Conditions of Pretrial Detention, the Yale Law Journal, Volume 79, Number 5, dated April 1970, pages 941 through 960. I quote, "Each day, 100,000 people in the U.S. are being held pending trial. The average period of detention ranges from 6 weeks to 8 months, unquote." Again, this was from an article in 1970. In an article from November 2020 in Prison Policy Initiative, I quote, "Nearly 500,000 people are detained pre-trial. In other words, they are awaiting trial and still legally innocent," end of quote. So in 1970, we were looking at 100,000 people that were being held pre-trial. And then in 2020, we're up to 500,000. 500,000 people who are being held in our jails, in our prisons, in pre-trial, they are innocent. Why is this? Many are not a risk to society at all. It comes down to the fact that many people cannot afford bail. If you were arrested today, could you afford a $5,000 bail? How about $10,000 or more? Most people in the United States, and I've heard this several places, but most people in the United States are living from paycheck to paycheck or are one paycheck away from being homeless. Do you have assets for the collateral? Many people do not. Historically, minorities face much higher bail amounts than non-minorities. In the United States, a person cannot be held indefinitely or for an excessive amount of time awaiting trial. But of course, there's no specific definition of what this means. A few states have put in time limits, but the majority have none. I want to give you something to think about. There's a case of a gentleman that spent 6 years, 10 months in Rikers Island prison awaiting trial. He finally took a plea deal. Think about that. This man spent 6 years and 10 months of his life in Rikers Island and technically was innocent. So I'm going to close out this episode. I just wanted to give you some food for thought. I hope this episode was enlightening for you on several of the reasons why the U.S. has such a high conviction rate. We will be back next week with our interview format. If you have any questions or would like to contact us, please go to www.legalpawns.org. Please share this podcast with others who are interested in making a difference in the U.S. justice system. Like and review us on the platform that you listen to this podcast on. Again, thank you so much for your time and listening to this podcast, and I will talk to you next week.
This podcast of Legal Pawns is for entertainment purposes only. Nothing in this podcast should be construed as legal advice. If you need any guidance on your legal issues, please seek out the advice of a licensed lawyer. All thoughts, opinions, advice, and beliefs of our guest and/or material presented are not necessarily reflective of the opinions, thoughts, and beliefs of Legal Ponds and any affiliates of Legal Ponds.